So this is the note I had promised to send. This to enable you listen to it before our next class, which is tomorrow, or our class on Thursday. So what we are basically going to be doing in this note I'll be sending over to you is on vitiating elements. So what I mean by vitiating elements is other things or things that can vitiate, that can reduce the enforcement, or that can even take away enforcement from contract, from whatever contract one has been involved in. Remember, we started with the elements that actually that contract is composed of, and we discussed offer, acceptance, consideration, and intention to create legal relations. I told you if all of that are in a contract, it makes the contract valid. Well, like I used to say, then the law of contract, it is not always a straight way. There are times, or would I say there are exceptions, because that would, if we want to be strict on our principles, that means one is giving room for those that want to defraud, or those that has intention to make a contract to terminate the effects of a contract. Now we are actually giving them the opportunity to do so without having room for an opportunity for an innocent party to get redress in the court. And so that is why we have vitiating elements. So these vitiating elements, they are elements that, if they are found in contracts, it makes the contract mostly voidable or void. And so the essence of this is so that you can be aware that if you are into a contract as students of management and intending insurance personnel, intending accountants, business administrators, and so on, you have to be careful when your employers, or when you being, if in the case where you are the head of your company, when there's a contract in which all of this, you sense things that we're about to discuss in a contract. And so what we call vitiating elements, they are mistake, misrepresentation, undue duress, and undue influence, and illegal contracts. If these are in contracts, then one is for sure to then see the legal effects of all of this. And so let's start with mistake. So I know in your mind already, you're thinking, oh, what is mistake? I know what mistake is. Yes, you know what mistake is. Excuse me. But when it comes to the law of contract, mistake is not as you would always say it is. So I want to give you an example. An example goes that Let's assume that you brought you want to sell your phone. It's a Samsung phone, right? And a friend of yours had seen it and had liked it, and you both agree. He said he would like to purchase that phone from you, and you agreed to price, and he sold it, and he came back. He said, "But I thought it was Samsung A55. I didn't know it was A53. I made a mistake. Please, I can't go ahead with this contract because I bought it with a mistaken belief that it was some other model." In the law of contract, it is not seen as a mistake. That is not a mistake. In the law of contract, what it means is that you wanted a phone, you had seen the phone, or would I say you wanted a phone and you got a phone. And so you cannot come back and say, oh, you made a mistake. All of that ought to have been trashed out. You can always have asked the person your friend who had it. All of that should have been cleared out, before you went ahead, make payment and all. Not that you come back and say, oh, in law of contract, that is not mistake. But I'll give you a scenario which in law of contract you see as mistake. And that scenario is that your friend has two types of phones, or he has two phones with him. He has a Samsung A54, A53, and A54. He said he wants to sell one of the phones. Now, in your mind, you had the intention of buying an A54, but he has the intention of selling the A53, being the oldest model with him. Then, at the point of exchange, you discover that he had exchanged the A53 with you. In that place, it is regarded in the law of contract, that is mistake. Now, why we call it mistake is that this mistake is called mutual. It's a mutual mistake. You made a mistake, the buyer made a mistake, the person who wants to transfer also, the vendor made a mistake, and the purchaser also made a mistake. That is, they had a mutual misunderstanding regarding the object of transfer. And so in law of contract, that is seen as a mistake. In a process where you did not really understand it, I want you to listen to this very well in connection with your test that you'll be reading. It is better I explain it in examples so that you can get it better. You can also look at it through the example that I've given here. So I said in law of contract, mistake can manifest itself in three forms. We have the common mistake, we have the mutual mistake, and we have the unilateral mistake. So then it's common mistake. So in the law of contract, common mistakes means you both made a mistake regarding the same thing. So the mistake is common between the two of you. Okay? You're mistaken on the same thing. And so in law of contract, we see that as mutual mistake. And so the example we have here is that, let's say, for example, you want to buy a property. The purchaser and the vendor, they are both in Lagos. All right. And of course, the way we do contract nowadays, you can be online, you can wake up in the midnight, talk about it through a chat, and, you had both agreed, okay, to meet at 5 a.m., maybe online, And by that 5 a.m., you both had drafted the contract and have done electronic signature. You have signed electronically. Not knowing that as at that moment, the house has been burnt or had caught fire and was burning at that moment. Of course, the purchaser may have not been informed at that time. So in the law of contract, the essence of this common mistake is such that what we can see now is that the object of transfer, the object of the contract itself, or will I say the subject of the contract, has been destroyed. So in the law of contract, they are both mistaken as to the existence of the subject of the contract. And so in the law of contract, it is same as mistake, which we call common mistake. A mistake is common to the both parties regarding the subject of the contract, right? The same subject of the contract, the same thing. Now then, let's go to mutual mistake. Mutual mistake, the example that is readily available is the example of the phone that I had given earlier, that I said a friend of yours had 2 phones and you decided to sell one of them, but you were both mistaken as regards the model. So that is a mutual mistake. It is mutual because, of course, it's between the 2 parties, but then it is regarding different thoughts. So the parties had misunderstand each other. And so regarding that is seen as a mutual mistake. Unlike common mistake, where the parties make the same mistake, but in this case, the party made mistake, but because they made the mistake on different things. In this case, they misunderstood each other regarding the model. And so I gave another example here. The example of the car. The person who had wanted to sell his Peugeot 504, but the other guy thought it was Peugeot 505 he wanted to sell. And so that is for mutual mistake. For the third one, which is unilateral mistake, this mostly is a mistake that is made by one of the party. One of the parties making that mistake, and the other party is well aware of the information, knows this person is making mistake, but refused to redirect him or to correct him. He actually intended for him, it will be in his benefit that that person had made the error. So correcting that person may have affected his business. But then in the law of contract, it is seen as wrong. And so we see it as a unilateral mistake made by one person, and the other person is aware of the mistake, but it still exploited the situation against the person who had made the mistake. And so in the law of contract, we see it as wrong. Going further, after we had explained the types of mistakes that we have, now mistake also takes different forms. And you already know how important it is for us to always explain contract in terms of common law and of equity. So when we are talking about mistake, we have mistake in common law and mistake in equity. So mistake at common law, it takes, the view that where a mistake is such that it prevents the formation of a contract, then the purported contract is void. Okay? So the effect of mistake generally in the law of contract is that it renders the contract void. It's void ab initio. So mistake at common law comes in different forms. We can have mistake under mistake at common law that is under the subject matter, where what it means is that the parties are mistaken regarding the subject matter. Okay. And so remember we mentioned in the example I gave in common mistake, where I said the parties are mistaken regarding the house they wanted to contract upon, which had been burnt down. So that's the subject matter of the contract. The next is the terms of the contract. Okay, the terms of the contract. Now, they actually wanted to enter into a mistake, into a contract, but then they have issue regarding the terms. And so we can put the example of a friend, the person who wanted to sell a phone, but had two different types. Now, the term, or would I even say, the term could be that this is the type I want to buy, and that's the other type you want to. I would have preferred that you sell to me. So also, mistake can come under parties to the contract also. And that mostly happen under unilateral mistake. Because most of the time, it has to do with identity. You want to contract with one person, and that person, you mistook another person for that person who you had wanted to contract with. But instead of that person telling you that I am not this person you had intention, but because of their economic gain, decided to still disguise as that person. And so that is seen as mistake. And mostly it happens under unilateral mistake. Okay. And so this mistake as to the parties to the contract. So at common law, mistake is void ab initio. So let's look at equity. You know, as we already have it, that equity, the essence of equity is to bring about fairness, right? So in the cases of operative mistake, equity follows, mistakes that we have mentioned earlier. In equity, it follows common law, and that is that the contract is void. But when a person enter into a contract under a mistake which is non-operational, which doesn't have to do with the subject matter, if the subject matter has been destroyed, so what else can you remedy? Nothing. There's nothing equity can remedy anymore. Equity just has no option but to render that contract void. So the contract is good at common law. Okay? So the mistaken party, when a mistake is non-operational, when it is not a subject matter, it doesn't go to the roots of the contract, then equity can try to revive it or try to protect the innocent party, okay, in order for that person not to go without any remedy. And so all of the remedies that we have under equity are rescission, like treating that contract as if it never came into existence, right? Ratification, that for the other party to like, oh, so if you are buying, let's say, for example, if it has to do with um, just terms of contract that are not very important, then the other party can say, let me, I have to forego whatever it is, but maybe you give me a little bit, a little thing to assuade me and all. Then we have the case of, we have refusal of specific performance. So in the case where there's a mistake and the other person is asking that, oh, there should be a performance, the law can come in, equity can come in and say, oh, but there's a mistake here. And so this other person cannot perform it. The court can refuse, or equity can refuse the performance of that contract. So moving forward to now another area where we can, another subtopic under misrepresentation or under mistake is documents that are mistakenly signed. And so most of the time, we normally tell our people or whoever that we are in contract, you do not just sign. In life, generally, you do not just sign a paper. It is wrong. The right thing to do is to read any paper before you sign them. Even if they are told you, oh, we have read it. But then you still have to read them. Because under the law of contract, the general principle is that when you mistakenly sign a contract, then you are binded by the contract. You are by whatever contract that your signature is upon, then you are binded by it. You are bound by such contract. Okay. But however, there will always be equity that comes in favor of some persons. You know, for example, in the case of a person who had signed that document mistakenly, for example, I would always use the case of a person who may not be able to read or write, or a person who had the kind of, some people have disabilities and may not be able to read properly. In that case, if it is not properly read to them and they sign it, the law of equity will be there to protect them. But then, if the law of equity would actually want to protect people who had signed mistakenly, then they cannot come under some headings. There are some people that that's like they could just want to misuse the opportunity and want to just come anyway. So the nature of the mistake will be checked before anyone can come under this defense, under equity. Restriction relating to person who can invoke the plea. It's not everybody that can invoke it. The person that can invoke it must be innocent party who had read or who's that the paper or the content of it wasn't properly read to them. And a person who is negligent cannot come under this defense, under equity as well. You have to have seen to have been careful and diligent and diligent in your activity before you can come and be protected by law of equity. If not, the general rule is that if you had signed a paper without having read and understood it, then you are bound by such contract. And this brings us to the end of mistake. So the next one in line for us is misrepresentation. So what is misrepresentation? So misrepresentation has to do with ordinarily when we're talking about contract, in law of contract, people make representations. That the representations are like in terms of their contract. Oh, this is what is the position. I want to buy this phone. When you buy this phone, you get this. You get such features, you will get these features. But the problems comes when those representations are deceitful or they are not properly stated. And so it is in that case, I would say they are misrepresentation. That is, people misrepresented facts and a lot of things in the course of their negotiation. And so we also said misrepresentation may affect the agreement and it may either render it void or voidable. Remember, under mistake, we say it will generally render the contract void. Excuse me. But when it comes to misrepresentation renders the contract void or voidable. So for misrepresentation to have operational effect on a contract, it must satisfy the following. For you to say, oh, this is a misrepresentation, then number one, it must have induced the other party The other party may have, because of that statement, enter into a contract with you or with the person who had misrepresented. If not, it will not be couched under this subtopic, or would I say under this topic. You cannot say something is a misrepresentation when that person hadn't used it, or it wasn't the reason why you had entered into the contract. Then it is not a misrepresentation. So, number two, it must be of fact and not of law. Misrepresentation must be made as of fact. So misrepresentation must be one of fact and not law. In this connection, the mere boast. So when you are saying it should be of fact and not law, there are times that people are just saying, oh, this my car is very good, is this, is, or when they are saying, or when the person says, I think, in my opinion, those statements may not be seen as misrepresentation because those statements are not the real situation of things. It's just somebody making an opinion. And so that opinion should not be what will make you, or should not be what should induce you into a contract. If a person is making a statement of opinion, then you're expected to verify such. It's different when somebody is categorically giving you an assurance. In that case, you really don't have to go further. You may have trusted them because it is their business, it is their trade. And so you don't want to go further to make inquiries because they have said they're giving you their word, which is different from them giving you a statement, giving their word to you as of opinion and not of fact. So number three is that the statement should be of fact and not of intention. So a promise or a statement of future, intention means something that they have in mind. Something of the future that has a kind of future characteristics to it. They are not misrepresentation. It doesn't constitute misrepresentation of fact. The next one is that the statements must have been addressed to the person that is misled. You cannot say you were just walking by the road and you heard that if you buy this phone, it will not spoil for life. And you went to buy it, when the statement was not actually made to you, it was made to another person. Even if those representation may be wrong, it wasn't addressed to you. So the misrepresentation must have been addressed to the person who has been misled before you can come out and say you have been some fact have been misrepresented to you. So the number five, the five part of this says silence. So under this, the general rule here says silence is not misrepresentation. But in certain circumstances, silence does amount to misrepresentation. So when somebody, you're trying to ask it, no, you are pricing, at times, out of, when you see a product, you are so happy with the product. And so at times you'll be making some assumptions. This product will be this product will be that, and all of that. In that process, you could be saying some things, and the person, the vendor may decide to keep quiet. Under the law, if silence doesn't amount to the general principle says that his silence does not amount to misrepresentation. But the exception is that misrepresentation in certain circumstances, silence in certain circumstances would amount to misrepresentation. Number one, where a contract of utmost good faith. So in this kind of contract, that means contract that's it is seen as of almost people had faith in you. People really trusted in you. So in such a contract, you must show utmost good faith. By so, you cannot say, I was silent, I didn't answer you when you are asking this question. In such a case, then it will be seen as wrong to be silent. I will repeat, and it happens mostly in sale of land, in shares of a company. You want to buy a property from somebody, and you are making some assumption the person will not correct you. This land is not a swampy place, and you kept quiet. And the person, because they know you are the owner, they are trusted so much in you, and you actually say because you cannot come under the protection of silence. And so it goes to shares. A company is expected to disclose everything that's whatever shares they want to sell encompasses the situation of their company to intending purchasers of their shares. Because of course, there's no other place to go, and they are trusted before they would say, oh, I want to invest in this company. So in the cases of contract of good faith, you expected silence will not be a defense. The next one is fiduciary responsibility. And so in the cases of like a guardian or a ward, a principal and an agent, such relationship are very close relationship. And as such, you're expected to disclose anything when it comes to contract, because the person had good confidence in you. And so, for example, when you're talking about parents and their children, but we are using guardian here because this happens mostly in maybe guardian and ward, principal and the agent. You're expected to disclose, a principal is a person, maybe you own a property and you are giving it to an agent and you are giving that agent your authority, letter of authority. Whatever contract, whatever thing that agent will do on that, he should disclose everything and not withhold anything from his principal. The next one says change of circumstance. If at the beginning of a contract, the situation is that, maybe this thing is good, this vehicle is functioning well, this, this thing we want to transfer is in good shape. But at some point, something had happened. In that case, the law expects you to disclose to the person who is purchasing, because there's a change in the circumstance of the product or the essence of the contract. Then there should be a disclosure of what circumstances have changed, even without the other person asking. And the next one says in the cases of full disclosure. So a person is not obliged to speak, but where he speaks, he must not withhold anything. In a situation where, it doesn't have to do with any of the four that I had explained earlier, or three that I had explained earlier, of course, you may not decide to talk. But if at least you must talk, you must say everything, not withholding one thing from the person. Now, what are the types of misrepresentation we have? We have fraudulent misrepresentation. Of course, in the name, it means when a person misrepresented some facts knowingly, they know this is wrong and they misrepresented those facts. That is, a person is fraudulent. It's called fraudulent misrepresentation. Another one is making a statement without believing in its truth. You yourself, you are doubting that truth, but because you want the other person to purchase or to enter into contract with you, you went ahead and made such misrepresentation. Also, in the case of reckless presentation, then that is also misrepresentation. You don't know if something is true or false. You just made it. I know, but you are not very sure. then that is also fraudulent because all you had in mind was just to sell or to go ahead with the contract. So the next is innocent mistake. So this happens in a situation where a party innocent misrepresentation, where a person innocently misrepresented some facts and has no intention to deceive the other person. When you make a representation truthfully, although that may be wrong. So that is an innocent misrepresentation. The next is negligent. Negligent misrepresentation. This was the type of the latter part of misrepresentation that was actually coined now. So the concept of negligent misrepresentation was when it was developed, it was developed with the intention to make sure that people take up their responsibility. You that you call yourself an estate agent, you must show utmost good faith. You must have done your work with due diligence, with duty of care. A doctor cannot just say things. They are expected to have shown duty of care, and they must be careful when actually in their work, when they are saying things. That's why at times you will notice that doctors, they actually have the same thing they say. They will say, we tried, but I don't know how they put it now, So one have to be careful in making presentations. It's best, So what are the remedies available? We have rescission, because we know that rescission is going back, like saying this thing doesn't happen at all, that this contract never happened, bringing parties to the place they were before the contract. The next is damages. We also have, and so we know that under damages, it means to be compensated for whatever the other band had incurred in the process. So quickly, let's look at duress and undue influence. So as it is now, we have discussed mistake, we have discussed misrepresentation, and by now I expect you to know what they actually mean and how they affect contracts. So the third one is duress and undue influence. So under duress and undue influence, what duress actually means is that when a person categorically forced another person by threat to their life or to their properties or to people that are close to them, threats to these things in order for them to enter into contract with them. That will be seen as duress. And under the law of contracts. And so under that, we can see duress to goods and duress to persons. But it has been discovered that nowadays, when it comes to contract, it doesn't always happen in that way again. People don't actually put gun behind your head saying, oh, if you don't sign that contract. It may happen, but it doesn't really happen mostly like that anymore. And so what has been discovered is economic duress. So what it means is that people putting, you can also call it commercial pressure, where a person is forced or where a person is told that without doing this, a contract will not go forward. Okay? where A and B had entered into a contract. And at some point, the other party felt, oh, the other party who is expected to do at the point when they're expected to conclude or conduct their own part of the contract. They said if the contract will not be reviewed, that they won't go ahead with the contract, basically because they know the other one has no option but to go ahead with the contract. And so here we can call this economic duress. Economic duress. And most of the times nowadays, it could happen because of the rise and fall of dollar in exchange with naira. And so if you see somebody that you have agreed to sell some things for them, and because of the rise in dollar, things had increased and you have no option but to go back to them. So what the law of contract is doing is that the person should actually have an option, number one, option of negotiation, and also option of deciding to say, oh, I'm not going ahead with this contract or not. That either the person should have the option of number one, that they have option to not go ahead with the contract and look for something else. Number two, that they have the option of negotiation. But where all of these two things are not there, because there are times people will just because they know you need this thing so much, they will come, if you don't pay our bill, then we can't go ahead with this contract. And so you need to please do a lot of reading regarding the cases that you can find under this. That's for duress. So what is undue influence? That's for duress. We had explained duress. So like I said, duress can come as of goods. We have duress to goods, duress to persons, and economic duress. Okay. So what is undue influence? So in principle, undue influence was designed to give relief where in circumstances not amounting to duress. In cases where you cannot say this is duress, then it is like another relief. Is another principle that was couched where a case is not duress, but then it has been seen that something wrong had happened, wherein another person is taking advantage of the other. In that case, it will be seen as undue influence. This mostly happens in cases where a party has more power over the other. Then in such cases, it will be seen as undue influence. And this mostly happens in the cases that we had listed here, in parent and child relationship, doctor-patient relationship. If you have a doctor, you mostly respect them so much. You tell them a lot of things about you. We may have people that may not disclose a lot, but if such people, a person who is taking care of your health, want to enter into a contract with you, there's a way you are nicer to them. You want to believe what they say. You want to give them, if the thing is meant for 10 naira, you can just say, oh, because you're my doctor, I can sell it for you 5 naira. Or I will not even take. But what the law is trying to protect is that where people now take undue advantage of the other person because of that relationship, then it is seen as undue influence. Okay, it is seen as undue influence. So, without wasting your time, let's quickly move to the last one, which is illegal contract. Illegal contract. So just like the name implies, contracts that are not acceptable contract that the law frowns at. Number one, contract that contravenes the rules that are laid down by statutes. And I know by now you know what statutes are. Those are laws that are made, by the legislators of each country or states or a local government, or contracts that are illegal and it contravenes the rule of common law. So we are going to work on it just this way. Number one, contracts that are illegal by statutes. So if a law says this is wrong, the performance of a contract under such is illegal. So if you cannot come up and say, but I didn't know. Like we would always say, there's nothing like ignorance in law. You are expected to know your law. It's advisable that you can, all of these laws that we have mentioned so far, you can decide to actually listen to them. I mean, download them. Most of them are soft copies, they are online. Download them, the Illiterate Protection Act, the statutes of limitation, anything that we have mentioned here. As time goes by, you also treat sales of goods. Try your best to download sales of goods act, and it will really be of a good benefit to you, because in law, there's nothing like ignorance. So we said that contract that are illegal by statutes may be declared illegal either as formed or as performed. As formed means during the process of forming, when you are trying to sit down together to negotiate, when something is wrong, that will be seen basically as illegal, because from the onset, you are known. And so here we have an example of a man of a country where it is said that if anyone will sell linseed oil, then such a person should have obtained license. But the other man who is negotiating with this company told them that they have license. And so because of that, they can negotiate. These people went ahead with the notion that the other has the license, but they did not have the license. And after they had transferred the goods, it was in the process of trying to execute or to enforce a contract that it was discovered that they do not have the license. And so at that point, because from the beginning of the contract is illegal, even the man that was deceived, the vendor that was deceived, could not get any relief because the contract is void. The contract is illegal. So when it is illegal, there's no remedy. And I want you to have it in your mind that this is general rule, okay? So the next is that illegal as performed. If it is in a statute that if you want to sell a fertilizer, you must list the chemicals in that fertilizer in the invoice. But the person, during when they are writing the invoice, they didn't put down the active ingredient, active chemicals in the fertilizer. It was discovered, or it was the court ruled that was illegal as performed, because it is the rule, it is statutes, it's by the statutes as recommended that this should be done. If it's not done, then it is illegal. Okay, so please know your laws. So let's look at contracts that are illegal at common law. So we have variety, a lot of them. I would like to run through them. Of course, the thing about illegal contract is that you will mostly know them, okay? But then it's good that I run through them for the sake of our class. Number one of it is that contract to commit a crime or a tort. Number one, contract to kill another person. You can then, when you want to get money for the service you are rendered, you want to sue. That's wrong. That's an illegal contract. Another is contract where two people agree that we are going to defame a third party. And if I have defamed this person from you, you are going to pay me, but the person refused to pay and want to sue the person. That's an illegal contract. And of course, illegality also attracts some punishment. Or, yeah, you cannot, in this kind of cases, you cannot murder another person and still want to go and get money. Okay. Case of defamatory statements, it attracts damages or some other release. The next one is a contract to defraud the revenue number. I say example is tax evasion. A contract that you entered and you had planned that you're not going to pay tax. That is illegal at common law. The next is contract that tends to disturb a country's good relationship with a friendly country. And I'll give an example and say, let's say for example, two countries that are friends, they are good, they are in good, they are countries that are in good terms. And the law is that you do not, let's say countries like, I don't know, maybe countries like Israel would say, we don't want the import of alcoholic drinks, but a person in their contract, they contract to smuggle alcohol into the other country. Now, remember, these countries are friends. So, you cannot, with your own, with a bad or illegal contract, both countries, it will not be accepted. And so it will be seen as an illegal contract. What's the intention of that is that if you are contracting, if you are doing things that are illegal to a friendly country, you are trying to disturb the country's good relations. And so that will be frowned at. So the next one says a contract involving trade with an enemy nation. You cannot secretly want to trade with a nation that is an enemy to the other. It is an illegal contract. And it could be that, it may actually not be you dealing directly with the company, with the country. It could be you dealing with another person in that country. But, it's illegal because they are both enemy nations. And so contracts are not meant to go, to take place between any citizen of that country and the other one. Okay. So, and most of the times, the way you see these enemies, that maybe they are fighting against that country, their armies are in that country, and they are in a war with that country. That will be seen as an illegal contract. Number 5 says contract be judicial to the administration of justice. In the process of administering justice in the court of law, you cannot enter into a contract to evade or pervert justice. For example, you are a witness and you enter into an agreement that I'll be the witness for you, and then you say some things that are prejudicial. They are not, or you say some things that are wrong in order to elevate the case of another. That is prejudicial to the administration of justice. You are trying to perverse justice, and so that is an illegal contract. So number 6 is a contract that tends to promote corruption in the public. Okay, so where it is seen that if you do this, you know what corrupt, we know nowadays that in the, maybe politicians now, where one politicians enter into an agreement to buy some things, to procure some things, and they inflated the price in order to get some things from the government. Those are corruption, and they are corrupt. It's against the public policy. Number 7, a contract to oust the jurisdiction of the court. And remember when we're talking about honor pledge, I hope you can remember in the situation where we mentioned honor pledge. Okay. When we're discussing honor pledge, we said in the case of honor pledge, and that's when we're talking, when we were under intention to create legal relations, we said honor pledge would not be would be acceptable because you're expected to honor the fact that the other party will do what they're expected to do. And so the rule does not make honor pledge void. Okay? Because it really doesn't have it has to do with the intention to enforce. It's the beginning that you are saying, oh, this contract will be enforceable or not enforceable in the court of law, you know. So it's not saying the jurisdiction, it's not ousting the jurisdiction of the court. The next one says contract tainted with sexual immorality. Okay. Let's say, for example, you decide to say, oh, you have a car and a lady that actually, or you have a van, and there's this lady that's her job is to commit for, she's into sexual immorality. So you sold or you rented the van to her, where and in that van there's actually a bed where she can perform whatever she does. And so that's what she has been doing in that van. So maybe in the process where she didn't pay, and you actually seek to court for enforcement. In this case, it is seen as an illegal contract because it encourages immorality, you know. And so the last one says contract that is prejudicial to the status of marriage. Okay, if you are entering into a contract in order to, you know, and a lot of people do that, you know, they contract marriage based on some things. And so we could see it a few of times when people are trying to achieve something, and without being married, you may not be able to achieve that. So they enter into contract to marry some people so that they can achieve what they want to achieve, you know, and subsequently they divorce. Those are illegal contracts. Okay. So, without missing word, you know, I really don't even have to tell you, you know, from the onset, that the effect of illegal contract is that such a contract is void. Illegal contract are void. It is treated as if they are never made. Treated as if they never occur at all in the first place. But then, and so yes, the meaning of this is that if a contract is void, then the other party cannot get relief. Even an innocent party in illegal contract will not get relief. Will not get relief. All right. So the rule as seen above is to the effect that property and other right transferred under an illegal contract is vested in the person that the property has been transferred to, and the person is called a transferee. Okay? You under illegal contract gave something to somebody, that person automatically withholds it because the law cannot starts, a judge cannot sit on a case that is illegal. You cannot place something on nothing. If there's nothing to place something on, then a judge is not expected to sit on such cases. But like I used to tell you, there are exceptions a lot, and all of these exceptions just to protect some people, and to bring sanity to the law of contract. And so this rule, these exceptions are one, that the party can recover money or property which may have been transferred if he is not a part, if he doesn't really have intention, or if he didn't enter the contract knowing fully well, or in connection, having a good connection with the other party, then such a person can actually gain some relief. A party can also recover what he has transferred to a transferee if he repents from the contract before it is performed. And let's say, for example, a person had asked the other person to bribe him, to give him money so that he can do some things. I know most of and they have agreed that you give me 500,000 so that you can get this contract. But on getting of that person, we thought, had a rethink, and then he approached the police, and the cash that he took there was marked. In that case, he has repented, and so he actually went a few of times. Some people would still go ahead because the police would actually need such as evidence, and they would have to, excuse me, they would have to arrest the other person so as to ensure that such illegality doesn't happen again. The next is that a party can recover property or money if he can establish his case without relying on the illegal contract. Like I said, it should be wrong for a court to start sitting on an illegal contract. But if a party can actually separate his case from that illegality, then such a person can get relief in the court of law. And so, looking at this part of illegal contract, a few of the times, or a lot of times, it happens. We call it contract in restraint of trade, where an employer says, to an employee, before you enter into my job, before you are a part of us here, you cannot leave this place and go and do the same thing. You cannot leave this place and pursue the same business that I do. Those are contract in constraint of trade, and the law frowns at it. The law prohibits it, but there are exceptions. Okay? The law prohibits it, but then there are exceptions. That is, if such a restriction had passed the test of reasonability. And when it comes to reasonableness like this, it is the court that can determine what is reasonable. It is the court that will determine the reasonability of such a contract. And number one, it is reasonable to between the party. Number one, where restraint will be reasonable in the case where it seeks to protect a property or other legitimate interests of a party. So let's say, for example, a person, a company that produces, that create apps, or maybe produces things. Let's say, for example, a company that produces a unique gin, or a unique drink, a soda that is very unique. A person who actually work in the section that has the trade secret of that company, it will be justified to restrain their trade. Because if that person actually leaves that company and goes ahead to open his own company, using that same secret of that company, then that is wrong. And so it's in that case that restraint of trade can actually be reasonable. Okay? Because it is the property of that company. The property of that company is that trade secret. You can find that under intellectual property. Those are also properties too. And so if that person would want to do business, it will not be in that line. It is reasonable enough to do that. So another thing is that it is reasonable as regards if that thing is reasonable as regards the interest of the community. So if when that thing is, that contract or trade is, in restraint of trade is made, it must be reasonable in the interest of the public. Okay, it must be reasonable in the interest of the community. So what then are the types of restraint that we have? We have restraint in a contract of employment. And so that's the one I had explained to you, that if Mr. A works with B company, and B company produces a soda, it's soda, a very unique soda that people like so much. And that person actually has the chemicals, the formulas, has their trade secrets. It is agreeable under the law that that person may be restricted regarding the trade that they can do if he eventually leaves that company. So it is accepted. Another type that we have is restraint in a contract of sale of a business. So this happens most of the times that somebody sells, a vendor that sells something to purchasers. He could agree with purchaser that if I'm selling this to you, then I will not sell to any other person again. And that's where we see dealership where you be is it dealership or something, where manufacturers have limited, they may have 10 or 15 people limited people that they supply items to, that they will not be allowed to supply to some other. And that is so that these people that they supply their goods to can actually benefit by selling to others. By selling to others. And so it's just like, somebody who owns a pharmaceutical company, then because he has a problem, he sold the pharmaceutical company, and like a year after, he recovered again, and he wants to open a shop beside the pharmaceutical company he has sold. That would be wrong. And so it could be in their contract that if you cannot open shop very close to me, it must be so meter away. It cannot be close to me. So those are contracts in restraint of trade that are approved, that are acceptable. Another is restraint in other contracts. We have restraints regarding prices and all of that, although these things are wrong, restraints in trade are wrong, but then they are acceptable if they are reasonable. So there are some businesses, if you want to, a lot of these associations that are into trading and all of that, they do have clauses which could say to bind their members that these are the prices you can sell your items, these are the places you can sell, these are the things, all of that. And that is in restraint of trade, which is not acceptable. But then it could be acceptable if those things are reasonable. I'll be expecting your questions in our class, as we'll be dedicating a little the beginning of our class on Thursday to questions and answers on this. So before Thursday, it is mandatory for everybody to listen to this so that can help us to conclude our work on Thursday. Take care.